Well, there are two ways to look at it. One is that the whole field of intellectual property rights actually came into being because one realized that unless and until you create some platform or form for protection of the outcome of a creative mind, there wouldn't be a lot of creativity which would be expressed. There will not be investments, there will not be many of the other things. So therefore it said, if you come and you disclose your creations or innovations in a certain manner, in a certain format to the government, then the government would give you certain monopoly on that creation on a quid pro quo, that you disclose that particular bit so that others get to know of it, and therefore it finds a higher utility in society. In turn, you get a protection, and that's what different forms of intellectual property rights are all about. Now, when you look at whether this would be a roadblock, it can be a roadblock if it is not used properly, like every other thing. The system has to be used properly. So the law or the system has in place certain other elements which are that as a result that you were given this particular monopoly, it is expected that you are then obligated to meet certain responsibilities as a result of that monopoly. So the law defines what you are supposed to do. Now, if you don't do that, then the law also says there are consequences of that. But that goes into the other side, right? But on the other hand, the law also provides for you to share that, use it for society, or let others use it in return for something that you negotiate. So yes, that is one part. On the other hand, the law also has some provisions which says that if under certain circumstances, if it is used for educational purposes in a classroom or for pupils or in teaching or for research, etc., then you can freely use that. And that comes under what are known as exceptions or limitations to that right. So long as you're within that, it does not create a roadblock. So long as the right holder does not overuse or misuse the right, it does not create a roadblock. It does, however, put an obligation on the people who want to use it to come to the right holder, take the permission and use it. So long as the system can work seamlessly that way, it does not become a roadblock. It can become a roadblock provided either party either decides not to negotiate or a party overuses or misuses their own rights. I think what we need to do is, first of all, without becoming too legal about it, because most of us who are not students of law, okay, and we are researchers or we are students, I think what we need is some sort of a program which would educate us on the basics of it and tell us through either manuals or programs or whatever, bring in and tell us that, look, if this is the law, this is the best way or the most optimal way that you can use it for your purposes, so that you then go and start using it and get the benefits of the law. Absolutely. For example, why are newspapers, say weeklies on every Sunday, why can't they come out with a column which says it's a series of those and says every column does? Or you have some websites or you have something, just start getting some of that. But it should be done with authenticity, it should be non-emotive, and it should be purposeful. If it's that done, I think that's ideal. Let's take the example of Tagore. Since you put the name Tagore, it's good to be specific on some of these. That if you took Tagore, Tagore was the creator of the poems, of he wrote the lyrics to a number of, he even gave music, he created them. He derived a lot of those things from different folk and classical styles and other things where he did all that. Now, as that, he was the author of those works. What he did, gave those rights to Shantiniketan, which were out there, right? So Shantiniketan became the owner of that particular copyright by law, by an assignment from Tagore to Shantiniketan. It doesn't become automatic, okay? So he assigned it. Now the copyright law, as was existing then, was that the copyright would be with Tagore during his life, or to whoever he assigns it during Tagore's life, and 50 years after his death. Interestingly enough, when the 50th year after his death was approaching, Shantiniketan approached the government of India and says, why don't you change that copyright law and make it 60 years? So we get 10 more years, to control the way Tagore's things will be used. Government of India changed the copyright law and made it lifetime plus 60 years. So it went on for 60. When the 60th year was coming, they went and told the government, now why don't you make it 70 or whatever? Government said, no, 60 is good enough. So what happened? After 60 years, that's over now. Now you will see after the 60th year was over, now anybody uses Tagore songs in films, in other things, even takes his lyrics and has created bands. So you can see there's an enhancement of creativity on that part. It's no more tightly controlled. However, what remains in the copyright law is also something called the moral right. That if somebody uses that work of Tagore in a certain manner, even after the copyright has expired, and uses it in a manner that would be derogatory to the reputation of Tagore, then Shantiniketan now can step in on grounds of moral rights, that it is derogatory. So the copyright law looks at all these, there are provisions for these. So we need to look at these things in a very, very objective way and address these issues that way. The question that comes in that if I was inspired by somebody, and the other is I copied somebody. Now, if I'm inspired, that means I take inputs from there, it goes into my system, but then I create, right? I create. That becomes an inspiration leading to my creation. Copying would be taking it and reproducing it without a creative element. So the difference is, did you bring in an element of creativity into your work? However inspired you may have been from there. So the identification or the demarcation would be, how did you, or what is it? What are those elements in that which has come as your creativity, though inspired, not copied? It's a very, very thin line. For example, suppose you say that ever since I was a little child, I've been hearing Tagore's songs so much that just got into me. So now when I create, it all sounds like him. Now, right? So did I create or am I copying? Now, that will be the thinnest possible point, and that is where one goes into, it's like in Bengali, when you eat ilish, fish, to get the flavor of the fish, okay, you have to take out all those fine bones away, and so you start doing those fine splitting onto this part to go and identify and hit at that very, very nuclear part where you say, that's the creative element. So that's the challenge. We know that little knowledge is dangerous. Okay, too much of knowledge can create complication. But however, without oversimplifying, at least if we are made aware of certain elements of this, and therefore remove that scary element and bring a bit of objectivity, saying, well, if you use the system this way, it will be good for you. So we need educational programs for the general public, including people who are doing their studies and research, etc., to bring us up to that level. And then when it comes to detailed, where you do the fine splitting, we can go to the experts. But to the extent that we need to, because this is so fundamental, that if I don't get this right, I can be totally wrong. I don't want to be totally wrong. It's not the question of earning for profit or not for profit, for earning or not for earning. The question is that in the present parameters of law, am I staying within the boundaries of what I am permitted to do and use what I am permitted to do in a creative manner, whatever be the means? But so long as I can stay within the bounds of law, and when I say within the bounds means also taking advantage of the exceptions to the law, that also is within the bounds of law. Bounds of law does not mean you are tied. Also what a law gives me a long chain of things that I can do. So long as I can use that in a creative way and do it, let's all do it. See, when you go to digital copyright, after all, what is digital copyright? That means that something earlier we had all the things in print. Now what you've done, you convert that, you have two options. You either convert the print into a digital form or you create something in a digital form. Both are possible. Now the moment you have converted something into a digital form, you have already reproduced it. You have already reproduced it. So the first question is, are you allowed to do this reproduction and present what was there in that hard form into a digital form? So are you allowed to do that conversion? That's the first part. Okay, that's it. Second part is, having got the digital form, either converted from the hard form into the digital form or created the digital form out there, question that comes about, can you share that, and under what circumstances you can share that, right? And how do you share that, and what are the means of sharing that? Now that is where it brings you into the technology, that whole digital technology. Then you start exploiting the digital technology. There the first part that comes in is that who owns that particular piece. Now that again various options. One is you are aware who the owner is, then you know what is linked to that ownership, whether you can or you cannot, or have they given permission, have they not. That's where the copyright issues come in. There are other issues that come in where that it all appears somewhere in the net and you are not even aware who the owner is. Then how do I go about? Now again on those particular fronts, the law within its parameters has certain factors. You need to bring in those particular factors, put it to that digital content and see whether you are allowed to do that within the eyes of law or not. So it brings in a lot of responsibility in a responsible way of looking at the digital content, both creation of the digital content, archiving digital content, sharing of digital content and using digital content. And all this comes within the framework of the copyright issues. So we need to look at all these, and these are not that the present copyright law in India addresses each and every issue with that clarity. So if we need to bring an amendment, we should bring an amendment to the law. Therefore, we must initiate that particular process. Or if that's already certain aspects, if they're adequately there in the law, we have to translate that in a language for normal users in terms of a guide as to what they can or they cannot do, or for librarians or others. And so just about 6 weeks ago, I was delivering a lecture in Ahmedabad out there, where we had 150, 200 librarians, and they all raised such questions. So we immediately started a little project, which we hope to complete by February or March 2018, where we will try at least to start with, create a working manual for librarians in India based on the Indian copyright law, which will address both the print and digital media. Well, it's quite ambitious, but I think we'll do it. Well, first of all, the National Digital Library of India is a great concept. It's a great concept. Why? Because it is trying to really create links. Okay, it is trying to open up a window, of a single window where I as the user would hopefully go there, and that would give me an outlet or links to various resources. So I do a search, I know that it's available to in such and such place. I can get that particular thing from there for my work or knowledge or whatever. So it's a great project. I think and it should be encouraged. Now this digital project of India has got basically various elements to it. There is a technology element to it, right? The various means, the functionalities that are there. Now those technologies either have been patented somewhere in India or not. One has to go through a due diligence, process of due diligence to see that the technologies that I am using in the digital project library, am I infringing somebody or am I allowed to use that technology? So that's the first analysis that I need to do. The second analysis that I need to do is to see that when I'm producing that link to the different sources out there, am I allowed to create that link? Okay, and what are the, so apart from the technology which will come through patents, and am I infringing any patents, the next part is, am I allowed to make those links? The third part would be that when I'm creating, when I'm linking, what am I doing? And then I'll be searching the database of somewhere else, because that's how I will know. That data on data, which is the metadata, the question comes in, who owns the metadata? So we need to resolve all those issues, and they must be well documented in terms of metadata, who owns metadata, etc., etc., etc. So that is the part. Then having gone beyond the metadata, I go to the actual content. Now when I access the content, important part is that content which was archived by somebody else, because I am not archiving, it's somebody else who has archived it. I means digital library, NDL, but somebody else has archived it. Was that archived in a legal manner? Is that infringing somebody? In which case, if that infringes somebody and I give a link, I become a partner to that infringement. So I may be hauled up. So I need to look at those things very carefully. So what is the sort of due diligence and care? Like I said in my lecture, you share not with scare, you share with care. Remove the S. You share nevertheless with care. So what is that care that we need to take? And we need to go through that particular process so that at no stage, I mean, of course, you cannot guarantee 100%, but to the extent possible, to the extent that you do and take care, you need to take care of that part so that if at any stage challenged, or if any stage anything comes in, we have the appropriate answers to it. Okay, that we were not ignorant of the issues. So we need to put the issues out there, we need to assess the issues, we need to do the due diligence to it and put all that in a tight frame out there and then take it forward from there. It's like this, that when we talk about intellectual property rights in general now, and then you go to specifically in terms of patents or copyright or any of these things, one of the issues that comes in different, now again this is not a general thing in every law, but you can look into the Indian part of it. Affordability is a very important issue, right? So that if I create something and I price it very high, and this is something which is very essential for society, okay, then am I actually trying to take extra advantage of the monopoly that was given to me by the government? So the law has provisions, whether it's patents or copyright or any of the other things, issues of affordability. So access and affordability are issues that we need to understand. Yes, so there is a link in some way or the other.